आप सभी का हार्दिक स्वागत। अभी हम मुश्किल दौर से गुजरे हैं और भविष्य संकेत दे रहा है, तो हमें सावधानी बरतनी चाहिए। मेरा निवेदन जहाँ तक हो सके, एक सीट छोड़कर एक सीट प्रोटोकॉल कोरोना का जो गाइडलाइन है हम उसकी पालना करने का हमारा अपना प्रोग्राम है। मेरा निवेदन सावधानी के लिए आप एक बार ऊपर चढ़ने देखो, 5 का नाम देख लो। क्या हाल है? So yes, we are here, and I hope the darkness which we have seen in the last 2 months finally hits us with a rush of positivity, longevity, and prosperity. It is indeed a pleasure that the momentary pause which we have in such a Catholic and intellectual economy is finally resumed under the flagship of Ethos Rajasthan chapter. And we are here to be graced by members, especially on implementation of the judicial order. Before we proceed further, may I request all the esteemed guests to come forward and light us a lamp. सुबह करोति कल्याण आरोग्य संपदा शत्रु बुद्धि विनाशय लीलशक्ति मुस्ते, which means I fold my hands before the light when it makes prosperity or shifts its nest, good health, abundance of wealth, and destruction of enemies and enemies. People से बड़ा ज्ञान बहुत गहरा है। हर संस्कृति, हर समाज में किसी न किसी रूप में गीत प्रज्वलन करने की प्रथा मौजूद है। यह शुभ प्रथा होने के साथ में प्रतिमात्मक है, क्योंकि गीत प्रज्वलन प्रतीक है अज्ञान के अंधेरों में ज्ञान से उजाले में प्रवेश करने का। इसीलिए मैं निवेदन करता हूँ कि ज्ञान के उजालों से हमारे जीवन को प्रकाशित करें और गीत प्रज्वलित कर आज के कार्यक्रम का शुभारंभ। May I request all the esteemed guests to place the glass. May I request all of the Chief Justice to present the bouquet to our Chief Guest, Honorable Mr. Justice Kadesh Shri. May I request Shri Eklovi Prasad, Joint Secretary, Untitled Chapter, to present the bouquet to our Chief Justice, Honorable Mr. Justice Akil Qureshi, Chief Justice of Rajasthan High Court and President, Untitled Rajasthan Chapter. May I now request Shri J.M. Purohit, Treasurer, Rajasthan High Chapter, to present the bouquet to our guest of honor, Honorable Dr. Justice C. Kochari, former ex-Chief Justice Gujarat High Court, former National Governing Council member ILI Delhi, and former Treasurer and Executive Secretary ILI Rajasthan Chapter. May I request Sri Suresh Kumar to present the bouquet to Honorable Mr. Justice Sandeep Mehta, Executive Chairman ILI Rajasthan Chapter. May I request Shri L.P. Hathi to present the bouquet to Honorable Mr. Justice Vijay Ashwini, Executive Secretary ILI Rajasthan Chapter. May I request Sri Namu Singh Rathore, President of Rajasthan High Court Advocate Association, to present the bouquet to Honorable Mr. Justice Dinesh Maheshwari. May I request Sandeep Shah, Double AG, Rajasthan High Court, to present the bouquet to Honorable Chief Justice. May I request Mr. Mahesh Nandi to present the bouquet to Honorable Justice Mr. Vivek Dhari. May I now request Honorable Mr. Justice Sandeep Mehta to present the welcome speech and the lively esteemed guests in the August gathering.
My Lords, Honorable Justice Dinesh Maheshwari Saab, Judge Supreme Court of India. My Lords, Honorable the Chief Justice Shri Akil Qureshi, Honorable Dr. Justice Vineet Kothari Saab, former Acting Chief Justice Gujarat High Court, former member of the National Governing Council ILI and the Executive Secretary ILI Rajasthan Chapter, Honorable Justice Vijay Vishnoi Saab, Executive Secretary ILI, my esteemed colleagues, sister and brother judges, senior advocates, learned additional advocate generals, officers of the academy, officers of district judiciary, the young trainee judicial officers, and my dear advocate friends. It is indeed a matter of greatest pride that after a lull of 2 years, we have collected here in this grand auditorium of the Rajasthan High Court for resurgence of the academic activities of the ILI. I extend a heartiest welcome to my Lord's Honorable Justice Dinesh Maheshwari Sahab, who, while at Rajasthan, was an integral part of the ILI, and many fabulous programs were held in his guidance. Sir, for the last 2 years, because of this pandemic, we have slightly been delayed in the objective of the ILI Rajasthan chapter, which is otherwise the most active chapter in all the country in organizing such academic events. Time and again, the ILI Rajasthan chapter has organized memorial lectures of short duration. In addition thereto, we have had 3 grand programs of 2 days, one of which my Lord's Honorable Justice Maheshwari Sahab was the executive chairman at that time. On 13th March 2011, we had organized a seminar on harmonizing legislative, executive, and judicial governance in India, need for strategic initiative. On 26th November 2012, a symposium themed Justice, Judiciary, and the Constitution of India was organized for commemorating the Law Day. On 8th March 2013, a symposium on a need for gender-just society and role of judiciary was organized. On 12th April 2013, Sri Ramnarayan Vishnoi Memorial Lecture was organized on constitutional governance and citizens, delivered by Honorable Justice G.S. Singhvi Sahab. A discourse was rendered by Honorable Justice A.K. Sikri Sahab on reproductive rights. Sri Munilal Garg Memorial Lecture was organized on the subject of law and morality in respect of surrogacy, which was delivered by eminent jurist Honorable Dr. Justice B.S. Chauhan Sahab. On 1st of August 2015, the second Sri Munilal Garg Memorial Lecture was organized, presided by Honorable the Chief Justice Sri Amitav Roy Sahab and Honorable Justice Ajay Rastogi Sahab. The Rajasthan chapter ILI has been a bridging element between judiciary, academicians, and law practitioners, and in furtherance of its objectives, it has provided a platform for the confluence of ideas of various stakeholders in form of 2 days state-level workshop. These workshops have become synonymous with the congregations of highly experienced and intellectual individuals who zealously share their knowledge, expertise, and experiences on the subjects of perennial and contemporary relevance. Not only did these workshops prove to be a sangam of the professionals and academicians, but also provided the mental stimulation to all the participants. The first 2-day state-level seminar was organized in the holy city of Ranakpur on 19th and 20th April 2014. This seminar was presided over by Honorable Justice A.K. Patnaik Sahab, Honorable Chief Justice Amitav Roy Sahab, and my Lord's Honorable Justice Dinesh Maheshwari Sahab, as he then was the Executive Chairman of the ILI. The seminar explored various areas such as doctrine of pleasure, principles of natural justice, concept of role of opportunity in constitution, changing legal position on sexual offences and inheritance in succession in reference to rights of women, particularly the rights of daughters in personal laws. One of the highlights of the seminar was the participation of the stalwart lawyer, Sri L.R. Mehta Sahab. The second 2 days state-level workshop was organized in the city of Lakes, Udaipur, from 14th to 15th April 2017. The workshop was presided over by the Dignitary Honorable Justice Arun Mishra Sahab. The workshop was organized on alternative dispute resolution in special reference to arbitration, mediation, and plea bargaining. The third 2 days state-level workshop was organized in one of the ancient cities of India, Pushkar, on 28th and 29th April 2018. The workshop was chaired by Honorable Mr. Justice U. Lalit, Judge Supreme Court of India, deliberations were made on topics like appreciation of evidence, overview of Money Laundering Act with reference to criminal law, and development of information technology and its use in field of law. As my lords knows that your lordships has had a close association in continuing legal education of the judicial officers as well as the lawyers. When I was in the Bar Council, I would always request my lords to deliver the lecture, the theme lecture as it goes on the civil subject, civil law, and the train which my lords formed of the sections and the orders that still is very clear in mind with that objective, because there is a restriction on participation of lawyers in the Bar Council continuing legal education programs, that the lawyers should only be having 5 years experience. So now, under the auspices of ILI, we are trying to have an exchange of ideas rather than continuing legal education amongst the practicing lawyers of standing, and a real wonderful interaction between the judiciary and the lawyers fraternity. And sir, we tell you that all these three experiences which I just shared, they were really tremendously fulfilling and enriching. After the standstill time of COVID, now we found the opportunity and we requested my lords, Honorable Justice Maheshwari Saab, because lordships had accepted the Bar Council's invitation, and no sooner I came to know, I jumped into the fray and requested my lords to spare his valuable time by giving us an overview on the implementation of court's orders. And my lords, as always, readily agreed, because any interaction on academic subjects with the legal fraternity always is closest to the heart of my lords, Honorable Justice Maheshwari Saab. We are really thankful to you, sir. My lords, the Chief Justice, Justice Akil Qureshi Saab, is, as always, a fantastic leader, a fantastic team captain. The moment you put across an idea, he always says, go ahead, there is no restriction at all. We are deeply thankful to you, sir, for sparing your valuable time and taking out the time to bless us in this fantastic auditorium, which by chance is being used for the first time. I welcome Honorable Justice Dr. Justice Vineet Kothari Saab, who has been an integral part of the ILI Rajasthan chapter when he was in this state. Your immense contribution to tax laws has been a guiding light for all in the legal fraternity, sir. We warmly welcome you to this august gathering. My warm welcome to my colleagues, the learned judicial officers, learned advocates, and all participants. I'm sure the vibrant discussions which are to follow will immensely enrich us. Thank you. Jai Hind.
Honorable Justice Suresh Maheshwari started his practice in the year 1981 at the six circles of Jodhpur and High Court of Rajasthan. As the Honorable Lordship practiced taking on the civil and constitutional sides, while specializing mainly in civil, revenue, arbitration, and company matters. Lordship was a lawyer for revenue and excise department for government in Rajasthan, High Court Jodhpur, UIC Jodhpur, Municipal Corporation Jodhpur, Urban Improvement of Sudaipur, and Rajasthan Tribal Area Development Cooperative Federation, and various other cooperative banks, soil companies, hospitals, bodies, boards, and corporations. Justice Maheshwari took over as a judge of Rajasthan High Court in 2004. Lordship then transferred to Allahabad High Court and remained senior judge as an Lucknow bench of the Allahabad High Court till March 2015. Then Lordship took over as the Chief Justice of High Court of Meghalaya in 2016, and transferred to Karnataka. Justice Maheshwari took as the 30th Chief Justice of High Court of Karnataka in 2018. He took over as a judge of Supreme Court of India on 18 January 2019. An avid reader, a person having tremendous interest in sports, deep thinker, eloquent speaker and writer, and an advocate. May I now request Honorable Justice Sandeep Mehta and Joint Secretary of Iqbal Bansal to present the memento and shawl to honor the Resident Dinesh Maheshwari. Honorable Justice Sureshi passed BSc Mathematics in 1980 and LLB in 1983. Joined the bar and started legal practice in the Gujarat High Court in July 1983. My lord was appointed as the Judicial Central Government Standing Counsel for the Income Tax Department. My lord handled large number of service matters on behalf of government, also handled large number of matters from land acquisition cases, criminal matters, and matters pertaining to parcels. My lord was appointed as additional judge of the Gujarat High Court. Honorable Justice Qureshi was then appointed as the acting Chief Justice of the High Court of Gujarat in November 2018. Thereafter, Bombay High Court, and took over the Chief Justice of the Gujarat High Court from 16 November 2019. Having been trained as an hardworking, independent, and excellently briefing by recording his opinion. On 9th October 2021, we were graced as he is now Chief Justice of Rajasthan High Court. May I request Honorable Justice Vijay and Jail Police Gujarat Rajasthan Untitled Chapter to present the moment to ensure to our Chief Justice, Honorable Justice Akin Kulesh. Born in the Jain family of chartered accountants, Maida was completed become honors from Jodhpur University in 1978. After practicing as a chartered accountant for 26 years, Maida served with distinction of income tax appellate tribunal for 15 years. As a lawyer, practiced in tax and other commission and constitutional laws, arbitration and company laws for 20 years in Rajasthan High Court and Supreme Court of India. Academician, speaker at various national and international forums, table tennis player and music lover. Lordship was elevated as a judge of Rajasthan High Court in June 2005. Served as a judge of Karnataka High Court, Madras High Court, Gujarat High Court, and was appointed as acting Chief Justice of Gujarat High Court and finally back to his roots in 2021. May I request Honorable Justice Sandeep Mehta and C.S. Gurwani to present a bouquet and shawl to Honorable Justice of the Village. May I request Sandhu to present to Honorable Justice Rameshwar Dine. May I request Sri Vinod Sharma present the bouquet to our immediate object, Honorable Justice Suresh. May I request Sri Sudhi Dhaniwal to do the honors, please. May I request Sri D.S. Rao to present the bouquet to newly appointed Honorable Justice Anil Shah. I request Sri Hemant Bhatt to do the honors. May I request Dr. Nupur Bhati to present the bouquet to Honorable Dr. Reha Bhavani. May I request Mr. Devi Nandan to present the bouquet to Honorable Justice Sameer Jain. May I request Sharad Kimosha to present the bouquet to Shri Rajesh Kumar, Chairman, Market Supers. And lastly, may I request Shri Asivati Salsa to present the bouquet to Shri Sachin Acharya, Vice Chairman of Rajasthan. May I request Dr. V. Kothari, please raise up to the stage.
My Lord Honorable Justice Maheshwari Sahab, Honorable Chief Justice Qureshi Sahab, Brother Sandeep Mehta, Brother Vijay Vishnoi, other brother and sister judges, dear advocate friends to whom I now belong again, a very good evening to all of you. Well, it appears that since my association with the ILIs from the beginning, day one, in the Rajasthan chapter, Dr. Bansali and Justice Sandeep Mehta thought it fit to make me a part of this function. I'm very happy and grateful to them for all this respect and affection given to me. I think Justice Chief Justice would not know, but this chapter was born in a maternity hospital auditorium, Umaid Hospital. And Chief Justice Anand was the chief guest on that day, and I distinctly remember. And I was the treasurer. So while addressing the dais, His Lordship suddenly said, and the most important person, Mr. Vineet Kothari, the treasurer who holds the key to the funds. And that key has now passed on the hands after hands. And treasurer remains, of course, the most important person in the organization. And ILI, sir, I have been the part of governing council in some of the committees in Delhi. So we found this deemed units to be very proactive kind of institution to do academic activities in all the chapters. And Rajasthan chapter, we carried all along, and with the able leadership of Honorable Justice Maheshwari Sahib and others, we could provide a platform to the academic activities of this state. Several conferences were held even outside the Jodhpur town also, and they were very, very grand success. Friends, as we know, this, I was told when I entered this hall, this auditorium is being used for the first time for some kind of good activity. And I'm happy that the well begun is half done. So now onwards, at least this hall will be used for these kind of activities by ILI or other institutions which work in these premises. And ILI can really provide a good research background to all of us who are, and because I've been part of library committee there, we know a lot of e-library books and links and physical books are available there, and they can provide you access to the almost worldwide study material of the law field and other fields. And therefore, we should definitely use this platform not only for a formal kind of meetings like this, but perhaps academic activities. And I'm happy that this team has requested Honorable Justice Maheshwari Sahab to give a lecture on the subject which was most dear to his heart, I believe, because civil law is the authority not only, as we all know, but now being in the Honorable Apex Court, whatever His Lordship will throw light on the subject today will be a great pleasure and treat for all of us to watch. And one thing I overheard rather, Justice Maheshwari, that he has, Lordship says, some objection being called the guest to this home. So I withdraw my words of chief guest, sir, but you are, of course, a leader of the team and leader of all of us. And therefore, your presence here itself is a great moral booster for all of us. And I'll not stand in the way between the audience and Lordships. And I once again thank you all for remembering me on this occasion. Thank you very much.
May I request my Lord, the Chief Justice, Yaki Qureshi, to grace us with recitation and use.
Dignitaries on and off the dais, friends, ladies and gentlemen. I've not been given time limit for the speech. It's an indirect way of saying keep it as short as possible. And that's what I intend to do. Justice Mehta described me as an excellent captain. They say a captain is as good as his team is. And my team comprises of my dear colleagues, the lawyers, and the registry. So if you believe the captain is good, the team has to be very good. I don't know if I'm authorized to say this, but I'll take my chances. Just before the program started, Justice Mehta's short notes he must have prepared had landed somewhere else. So in a hurry before it was arriving, he already started addressing us. And when you speak extempore, it comes from the heart. And Justice Mehta always speaks from the heart. So he did not have had to worry about the notes at all. Friends, ILI is carrying out very important research. And research in field of law is probably more important and more relevant than any other branch, including in the branch of medicine. It was sometime in the year 2005 that Justice S.P. Sinha, in one of his judgments, famously said that the Constitution of India is a living organism, an organic body, but the rate of change is glacial. Less than 20 years later, I wonder whether this statement holds true today. The society is changing so fast. It is constantly in a state of flux, in a high state of excitement. At one end of the spectrum is a solemn resolve of we the people to achieve social, political, and economic justice for all, a pledge which the country cannot claim to have fully redeemed yet. It's work in progress. On the other end of the spectrum are issues transgressing international boundaries, the legal issues of humongous social, economic, and legal implications. Take, for example, the anti-dumping duty regime. The countries have found that there are some industries which sell their products at predatory price, making it unviable for the local industry to survive for long. If it is found that there is a causal connection between the two, the anti-dumping duty regime permits levying duty on this predatory price structure. Take, for example, international transfer pricing in transactions between associated enterprises. The multinationals have companies and subsidiaries across the country. There is a propensity sometimes to transfer the profit to a country where the tax slab is low. The income tax officer can examine these transactions and find out if the sale between the associated enterprises, that is parent company and the subsidiary company, are at arm's length or not. If not, he can tax it. The most interesting concepts are developing in international commercial arbitration on the concept of party autonomy. Whenever one of the parties is a non-Indian company, they can decide not only that in case of disputes arising will go to arbitration, but they can decide the venue of arbitration and seat of arbitration. They can also decide what will be the law governing the parties, the law governing the procedure, and there'll be a third law which will govern the agreement itself. And when this international arbitration, sitting in Singapore or Switzerland, passes an award, it'll probably come before you for execution, if the property of the judgment debtor is situated within your jurisdiction? The judgment debtor would say that the arbitrator in Singapore should not have applied the laws of Singapore, but had to apply the laws of India. And even if he was allowed to apply the laws of Singapore, he has misinterpreted those laws. The judgment creditor will try to convince you that there is a vast difference between setting aside an arbitral award and refusing to execute an international arbitration award. And you will have to decide who is right and who is wrong. No judge sitting in this court can be satisfied with his grasp and interpretation of the local, what we call the municipal laws. We must all familiarize ourselves with the international transactions and trends. And within these two ends of the spectrum is the struggle of the society to find its true identity. Today, across the constitutional courts in India, a fascinating debate is going on as to what are the boundaries or limits of the law. Where does the boundary of law end and the boundaries of personal choices, personal rights, personal religious and other beliefs? How far can the law govern what I shall write, what shall I read, what shall I eat, what shall I wear? Who should be my life partner or whom should I love or not love? Take, for example, in Sabarimala, one young woman went to the court and said that the archaic tenets of the temple, which prohibits women between a certain age group to enter the temple, are outlawed, hold them unconstitutional. The Supreme Court once held she's right, then had a second thought. Now it's under review and before the larger bench. Take, for example, the case of Navtej Singh Johar. Once, in Nas Foundation, the Supreme Court said Section 377 of the IPC is not unconstitutional. Later on, by the larger bench, Supreme Court said consensuous gay sex is a right of a person, of a citizen, and his privacy. The law cannot overrule that. One lesser known, but a very interesting case is of one Gulrukh Gupta. Gulrukh is a born Parsi. She has married a Hindu boy under the Special Marriage Act, neither of them abandoning the religion. Gulrukh Gupta went to Gujarat High Court and said that my parents are aged, and God forbid someday they may expire. The Parsi Panchayat will not let me enter the Sanctum Sectorium, Atish Behram as they call it, where the last rites of the dead body are performed. Declare that this is an unconstitutional practice and permit me to attend that. The matter went to the larger bench of the High Court and dismissed her petition. My view was in the minority. The matter is, I believe, pending in Supreme Court, but the Parsi Panchayat lawyer before the Supreme Court raised a brilliant argument. You may agree or may not agree, but see how important and how complex the today's life has become. He said, more than 5 centuries back, my forefathers came from Iran and landed at Sanjan, in a town near Bharuch in South Gujarat. And the rulers of the day assured my forefathers that the state will not interfere in your propagating and practicing your religion. 5 centuries later, will the courts in India tell me who is Parsi and who is not Parsi? My friends, all I'm saying is that these are fascinating days. All of you will play extremely important role in all these issues which will come before you from today and onwards. ILI is a think tank where it presents research. And without research, without thinking, the judges become mere rule applier. The real role is rule making. The judges of the constitutional courts in India cannot be brought down to the level of a tax collector in a stamp duty office. They have a much bigger role to play, and we need all the help and support which ILI can give in terms of research and in terms of inputs. Thank you very much.
May I request Honorable Mr. Justice Dinesh Maheshwari to give us today's keynote speech.
A very good evening to all. Honorable the Chief Justice, dear brother Justice Akhil Qureshi, my dear brother Justice Sandeep Mehta, Executive Chairman, ILI, Justice Vijay Bishnoi, my dear brother Justice Kothari, all my other colleagues of Rajasthan High Court, the senior advocates, members of the Bar Council, the Bar Associations, the judicial officers, and I understand the trainee judicial officers also here. Other learned advocates, ladies, gentlemen. Brother Justice Kothari has already shared one of my objections as regards the address, particularly when I was sought to be addressed as a guest here in this hall. And I'm sure none of us is a guest here. This particular hall, as most of us know it, a lot many efforts. This entire building, which is one of its kind in the entire country now, this hall had been a creation of the thoughts and sincere efforts of practically each one of us who had seen this building coming up. This hall was conceived, and maybe last 2 years or so had been a bit too challenging for all of us. So this hall could not be put to the use it was intended to be for. But it gives a definite sense of satisfaction that today we all are here, and for that matter, at the invite of the Rajasthan chapter of ILI, something to stimulate all of us, something to ponder over, something to think, something to ask ourselves, and then something to find answers also. But before I touch upon the subject which I had discussed with Brother Justice Mehta, a few comments perforce come up. Brother Justice Qureshi is spot on when saying that when you are speaking without looking at the papers, you are speaking from the heart. Even when you are looking at the papers also, I'll just adding on to that, even when you are looking at the papers and seemingly you are simply reading it out, somewhere your heart is asking you to say something more or extra or different. And very many times it does happen that it has been difficult for anybody who had been given a written speech to read out, to continue with the printed version only and to drift away somewhere else. Because I remember for myself that once, well, one of my associates had, after a great labor, prepared a speech for me when I asked for something to be prepared. I was given a written speech and I was supposed to be reading that out. So I did half of the reading, then said something extempore, then I picked some bits, some pieces from here and there. So all other, whoever heard it, whoever well had something to discuss, ponder over, talk, except one person who had been associated in preparing that speech. That person was absolutely sure that I have made a mess of everything. I should not have done it. Either I should have spoken for what I wanted to say, or I should have read it out. But anyway, old habits die hard, so maybe I would be doing the same mistake today also. So I may be excused for that. Brother Justice Qureshi would choose to invoke the expression accidental captain. So when something like this captainship and sports, etc., is talked about, I am again and again reminded of one very small happening more than 125 years back in a cricket field about one of the greatest cricketers. This I had been sharing with my friends very many times, but I'm tempted to share it over again. That Sir W.G. Grace used to be one of the greatest cricketers of his time. So once when he went out batting on the very first ball, there was an appeal for leg before wicket. So the poor umpire well raised his finger because he thought he was out. And those were the days not having those hawk eyes and these replays and all that. So Sir WG was a great fan following. The gentleman WG Grace, grand old man of cricket as he was called, he went to that poor umpire and asked him that gentleman, do you see all these people well sitting around this stadium? Said yes. Do you know all of them have come to see my batting, not your umpiring? Understand? So that 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 particular event I'd been sharing with particularly with my judicial officers to go on reminding themselves your role is that of umpire. And when you are umpire, so far as heroics are concerned, so far as anything of theater or is concerned, leave it to the player on the field. If at all anything of heroics are to be done, your duty remains to ensure that the entire game is played as per the rules, adherence to the rules, whosoever be the side, well, remains your duty and responsibility. And for that matter, well, after the empire, see that it's the next lesson from a field of cricket is that after the empire, because the empire is a person who is always remembered for and known for his mistakes. You would hardly recollect or hardly appreciate an umpire for delivering a right decision that he is always supposed to deliver. And a single wrong decision or seemingly unpleasant decision or unacceptable decision, and there would be so many question marks for the umpire. The other poor person after the umpire on the field is captain of the team either way, whether he is an accidental captain or he's a chosen captain. But then, these are the empires and the captains who ensure that everything always remains in place. The game is played not only in its spirit, but for the purpose for which it is to be played. The ethos of the game, the principles are maintained, the rules are maintained. And when we have a captain who is forthright, straightforward, looking straight only on the subject, only on his calling, only on his requirements, only on his institution, we can always be sure that every next step of the captain, whether it is a change of a bowling on the other end or change of the batting order, is always going to do a great good to the institution as a whole. And we can always look forward for the Rajasthan High Court, the entire Rajasthan judiciary progressing further in the able leadership and captainship of our captain, Justice Qureshi. So nice of you to be here this evening on this program and stimulating everybody with your thoughtful words. Friends, ILI, Brother Justice Mehta indicated about several of the past events. Brother Justice Qureshi also indicated about several different now expansions of the legal principles and legal callings and legal requirements and the legal systems as a whole. We had been discussing, as Justice Mehta indicated, about the constitutional governance, gender justice, natural justice, surrogacy, ADR mechanisms, PMLA, etc., in different seminars, different conferences under the aegis of ILI. And every time we have found that whoever participated there, well, came out richer not only in the contents, richer not only in the knowledge, or richer not only on some intakes, but richer in thoughts, with so many of stimulations at the same time, so many things to ponder over, and so many things to, well, progress on, work on, and develop on. That is what ILI had always been doing. And for that matter, yes, Rajasthan chapter had been one of the vibrant chapters across the board, across the country. We have noticed Rajasthan chapter's activities earned great acclaim. I'm very sure with all of you being now actively, energetically involved, this Rajasthan chapter of ILI is further going to, now with this pandemic, of course, I will be saying a few words about this pandemic we have gone through, but pandemic or no pandemic, ILI, I'm sure, the Rajasthan chapter particularly, although ILI itself has been contributing a lot in the development of thought processes, and that is very important, that has got its own significance. Rajasthan chapter continues to do that, and today's beginning always remains incomplete, half done. That is what I would expect, so that we are keen for the stage two, as soon as your Chief Justice took seat, my only comment to him was that whatever he has said had remained incomplete, and I would be looking forward for part two of his speech. So I don't know whether I would be invited or not. But even if, whether invited or not, but not to be called a guest here, as Brother Justice Kothari has rightly said. It's always fulfilling to be in with all of us, I would say, here in Jodhpur, where I had started to learn. There had been, and even today I see in this auditorium some of my seniors from whom I learned, some of my such judicial officers also before whom I practiced as a lawyer, and thereafter they worked with me in the registry or in various different capacities. I see some of my colleagues today adorning the bench. We see today, I would only say that it's a simple beginning and nothing more than that. Many more such or rather larger events are bound to come up, and we would keenly look forward to be a part of that. Friends, coming to the topic which we had chosen for the day, just to discuss a few aspects about. This particular topic regarding implementation of court orders that stuck to me as I had an occasion about a month back to say a few words on a talk on the 15th Chengappa Memorial Lecture for the judiciary of Karnataka under the aegis of Lahiri Advocates Forum. So when some topic was being discussed, we thought of discussing about various aspects relating to the execution or the contempt, and broadly and generally speaking about implementation of court's orders and their relevance. So when Brother Justice Mehta indicated about his idea of having a talk here, I thought this particular area needs our attention, and maybe in continuity with what I had discussed about a month back, adding on to that, and maybe we continue, we just think over, ponder over as to what is required for us to understand and do about implementation of court's orders, what we are doing, what we can do, and why it's to be done. Entering into that aspect of the matter, I would definitely congratulate ILI for this resuming these academic activities here. Last 2 years definitely had been quite challenging for all of us. But one thing is definitely sure, that when in the later years, the historians would be writing down something about how the humanity responded to this challenge of COVID-19. The dealings of our country, the response of our country all of us together would definitely be, for any historian to appreciate and sometimes to wonder also as to how the largest democracy of the world, with a huge population and huge challenges, was able to deal with this challenge in a comparatively methodical manner in comparison to, particularly in comparison to the countries, the nations, the societies who were otherwise supposed to be so-called developed nations, the developed societies. This distinction of developed or underdeveloped or developing, etc., I'm not on that. But yes, we together have been able to deal with this challenge also head on, providing for vaccination more than 100 crore doses, but this itself is by no means a job which could be thought of being taken up at that brisk pace. We have done that. Friends, coming together today, when we look for the hopes for the tomorrow, because there are challenges for the tomorrow. Maintaining of rule of law is definitely going to be a continuous concern of all of us. In this kind of a challenge of maintaining rule of law, I have chosen this topic, friends, particularly for the reason that whatever we have discussed, whatever we are discussing, we continue to discuss about constitutional governance or ADR or information technology or various other legal principles, evolving legal principles, as Honorable the Chief Justice indicated about when anti-dumping laws also we had to develop to deal with, to ward against and to save our economy from, well, somebody choosing to dump the material here and disturbing our economy. These all aspects and features relating to, essentially relating to substantive law. Even when we refine our thoughts, we sharpen our arsenal, we are ready to deal with them, we do deal with them. We need to ask ourselves that whether the same kind of zeal, enthusiasm, energy do we apply, and is it available to us to apply so far as implementation of the court's orders are concerned? To put it other way around, put it more simply, the kind of efforts we put in contesting a writ petition in a high court or a civil suit in the court, on all our proficiencies over the substantive law as also the laws of procedure, particularly the first four elements of the laws of procedure, as regards the summons, pleadings, proof, even judgment, lawyers and judges alike. The fifth element of the law of procedure, that is execution, how much seriously do we take it with the same energy and same enthusiasm, or we find somewhere that when it comes to, well, contesting a matter and having a decree from a court, every effort is put, every energy is put, and once a decree is, a final decree, a concluded decree is taken, and execution, well, goes somewhere else, whether it is assigned to a comparatively junior person or it is assigned to somebody, well, maybe a frontline senior lawyers, senior law professionals, how much energy and effort is put into execution. Put it yet differently, it is one of the measures of the concerns of the High Court administration always when they find that the execution petitions are those petitions which remain pending in our subordinate courts for comparatively excess length of time. Do we really apply ourselves? And if we do not, or if proportionately we do not, let us ask ourselves, what are the repercussions? What happens? Any proficiency of anyone, whether it is a lawyer or a judge, as regards law or the substantive law or the law of procedure, so far as the litigant is concerned, so far as the ultimate consumer is concerned, that may sound secondary for him. He is ultimately concerned with fruits of the litigation, if at all it is a litigation. The fruits of the litigation do not come by way of decree, they come by way of execution. The fruits of litigation do not come by way of, well, an order having been passed, issuing a particular writ. That writ having been gone into effect, thereby only the fruits do reach. Now, if they do not, which very many times they in fact do not, or the process is lengthened well beyond the control, like you would recollect only a few days back, probably in the month of October, the Supreme Court dealt with a particular matter, Dipali Biswas versus Nirmalendu Mukherjee. This 2021 SCC online, page 869 is there. A 3,000 rupees suit, a suit for recovery of rupees 3,000, filed in the year 1971, 4 rounds of execution litigation, not the 4 rounds of main litigation, 4 rounds of execution litigations that matter had gone through, all kind of objections against the auction sale, confirmation of sale, whether it could be done or not. 4 rounds of litigation, and 5th round it was of execution litigation that the Supreme Court dealt with recently in the month of October. And Supreme Court made a comment also that maybe this may be a particular case fit to be well put in the textbooks for a study of law of execution. The examples are too many, we all know. We all are reminded also of the comment that was made about more than 150 years back in that was a comment made, friends, in the year 1872, that the problems of a litigant in India starts after having obtained a decree. Today we may just ask ourselves about the problems, if any, examine the aptness of this statement also made 150 years back. Is it like that? Or Dipali Biswas are kind of one-off examples, not very often of occurrence? The reality lies somewhere in between. That particular statement cannot be taken to be a gospel that it's the courts are always lacking in the efforts towards execution and ensuring the foods reaching the needy, reaching the deserving, I mean. But at the same time, yes, the process do take their own time. There do arise certain complications, and sometimes a litigant may have a feeling that he has not got what was expected out of the litigation. For that, whether these are our judicial academies or this kind of a gathering, any other academic discourse, we need to, lawyers, judges, all, we need to ask ourselves, is it not that the methodical, structured process of execution provided by the Code of Civil Procedure is somehow somebody somewhere either tend to be overawed by the length of Order 21 or too many of the propositions available therein, or like Dipali Biswas's case, somebody somewhere tends to misuse the provision which are otherwise intended to ensure the rule of law to be maintained even when an order is to be executed. It's for all of us to look at those fault lines, provide for the solutions. This is needed, friends. This is needed because I just quote a terse expression in the case of Jennison versus Becker, where the Queen's Bench said in 1972 like this: if the orders of the court can deliberately be set at naught by a litigant employing for her own personal advantage such means as were here resorted to, and if indeed be the case that she has to go unpunished for her contumacy, justice vanishes over the horizon and the law is brought into disrepute. The bench also reiterated the words of Justice Curtis Raleigh that the law should not be seen to be sit by limply, while those who defy it go scot-free, and those who seek its protection lose hope. Friends, execution, implementation of court's orders is not only about the fruits of the litigation reaching to the deserving. It's much more than that. When we talk of rule of law to be maintained, maintaining of rule of law is directly dependent on the faith and confidence of all the constituents of the society. And the faith and confidence of the society, the litigant is also a part of it, well, directly relates with the efficacy of any particular system which we are evolving and we are executing or we are employing. The courts, the litigation process, we do everything in the code of law for the purpose of delivery of final decree, the verdict, whether by the trial court, by the first appellate court, second appellate court, Supreme Court, whether it's a writ jurisdiction, merely passing of a decree or issuing of a writ has never been sufficient. whether execution proceedings or contempt proceedings for that matter in the read courts also, we all are aware of. They are the areas to be attended at by all of us for all our other learnings about the constitutional governance and the rule of law and the any kind of system hitherto existing or further devolving to be a system for the purpose of progression of the society, maintaining the order in the society. Orders of the court are not meant to be mere papers. Orders of the court are meant to be finally implemented. And it is that implementation, as Samand would put in his jurisprudence, that execution is resorted to, the fifth element of law of procedure, is resorted to when voluntary submission to the verdict is withheld. So whenever there is not a voluntary submission, the coercing of the person who is responsible, the process of that coercion has to be taken up and employed with equal zeal, equal alert by all of us. If I could put it very simply, so far as Order 21 is concerned, or all other provisions of the Code of Civil Procedure concerned dealing with the law of execution, the simple concept and the simple idea had been and is, and that is what is contained in maybe the length of Order 21, is that whenever required, coercion would be resorted to, but proportion of coercion would be maintained. It is just the law's anxiety to maintain proportion of coercion that has led to several principles perforce to be provided in Order 21. It was meant for, it has been operated, it was supposed to be operated, and all of us are keen to operate it also. But when the theme is understood, that only idea is that, well, the court order has to be implemented, well, implemented to the extent it is required to be implemented, neither more nor less. So that proportion, maintenance of that proportion is all, whether it is Order 21 or even when you go for contempt jurisdiction also, what you look for is not disobedience alone, you look for willful and deliberate disobedience. The concept of maintaining a balanced approach is the hallmark of all the laws of procedure. In that anxiety of maintaining the proportion, if a disbalance goes towards non-implementation of the order or taking us away, we drift away from the theme of the order, the theme of the judicial verdict, which has to be complied with, implemented. The repercussions fall not only on the deprived litigant alone, they fall generally on the maintaining of rule of law as such. And if they do fall on the rule of law, they fall on all of us. That is why, friends, I feel that when it's a duty on all of us not only to ensure that the system functions, but also to ensure that confidence of all the persons who rely on the system is maintained. ensuring implementation of the court's order in swifter manner, in lesser cumbersome manner, is a bounden duty of all of us. We need to, these aspects are required, we are required to remind ourselves also about these aspects. And then, for that matter, within the framework of law, we can take cue from how different courts in different situations have evolved the methodologies and thereby have broadened the horizons, and the possibilities are infinite, friends. But yes, we need to again remind ourselves that it's not of always doing something which is out of box, or which is improvising, which is innovating beyond what is permissible in law, but within the framework of law, how we have innovated and what are the potential for us to innovate are the aspects for all of us always to look at, always to appreciate, and then work on them further. A few examples, and one of the classic examples of that is the methods which is very many times employed and employed fruitfully by constitutional courts, particularly the high courts and the Supreme Court. And that is the proposition of continuing mandamus. That when, with the development of law, particularly when several such features the courts have started dealing with, where passing of some order, issuing a particular writ was never going to be sufficient. Something or rather much more was required to be done rather than simply being satisfied by passing of a or issuing of a writ. The courts evolved, like the case of Vineet Narayan, we all know. The environmental matters, like continuing mandamus in the case, in orders after orders passed by the Supreme Court in T.N. Godavarman, as also M.C. Mehta, we all are aware of. Creation of some bodies like centrally empowered committees by the courts, and then those committees were dealing with day-to-day problems or day-to-day issues at the site, and then also reporting to the court, with the court not disposing of the matter, as we find that the definition of decree talks about suit is disposed of. So that disposed of is put at check in continuing mandamus kind of propositions, where the court would pass an order, ensure its compliance, look for yet further areas to be dealt with, and that is how successfully continuing mandamus has been. Even in the High Court also, well, we as a, myself also as a lawyer, as a judge also had been a part of, well, so many of such matters. Maybe they were essentially non-adversarial matters, maybe essentially public interest litigation matters, but what has been successfully applied in public interest litigation matters, not necessarily environmental issues only, so many issues of concern of public at large, where continuing mandamus has been employed. The courts have evolved further from continuing mandamus. When even in the classical civil courts also, when you have several kind of supplemental proceedings at your disposal, you ensure that the fruits of the decree would ultimately reach the deserving by passing such orders, and maybe by even modulating such orders when need be, so as to ensure that the decree finally to be made is not frustrated. Some provision like Rule 4 of Order 39, Rule 1, 2, temporary injunction, etc., we all always deal with. But a provision like, well, Rule 4 is a good indicator to all of us that whenever need be, you do modify, you do modulate even temporary injunction orders. It's a living exercise, it's a dynamic exercise, it's a continuing exercise. We need to go on reminding ourselves about the process so as to maintain the confidence of everybody and to ensure that the fruits do reach the needy, sir. Friends, continuing orders, multiple orders, has not remained confined to public interest litigations or environmental issues alone. A classic, another study would be some continuing orders like those passed by the Supreme Court in the case of Chitra Sharma. That was one of those early matters before the Supreme Court with the advent of Insolvency and Bankruptcy Code in 2016. Well, again, of course, the interest of the thousands of home buyers were involved, and the bankruptcy code, IBC itself, was in the process of evolution. The Supreme Court in Chitra Sharma's case passed one order after another order so as to ensure that the theme, spirit of insolvency and bankruptcy code is maintained, and at the same time, the interests of that same time, the home buyers, the frustration of the home buyers could be taken care of. Passing of one of order or giving one direction was never going to be sufficient in such kind of a matter. Yet another very small little example of the courts these days dismissing an anticipatory bail application is not closing the matter. Again, that disposal is not, counting of disposal is not the concern of the court. The more of the concern of the court is about ensuring the rule of law maintaining, ensuring the fruits reaching the deserving. Rejecting an anticipatory bail application, the court doesn't stop with the dismissed word. The court further passed an order. And not only an order, very many times we see the court passing the orders, asking the particular investigating officer to ensure that not only the person doesn't deserve anticipatory bail, he by this time ought to have been subjected to the rule of law. He need to come and he need to be taken care of. He need to be dealt with in accordance with law. You do that and report compliance. Now, this and report compliance is a process, is a method adopted by the courts in variety of situations, variety of areas. Reporting compliance, I'm not saying that in every case, well, every next day now we would be passing an order for reporting compliance, because there are certain matters where the compliance is bound to come up, and if the compliance doesn't come up, the methods are to be, the enforcement methodologies are to be resorted to. But by whatever methods we ensure the compliance to come up, execution becomes an integral part of our attention. Friends, various these aspects of discussions about somewhere some lack of confidence or lack of faith, I'm sure would be dealt with, would be checked, because in the courts, the judiciary as a whole, one of the pillars of the democracy is known to be that pillar on which the entire system could rely upon, whosoever he may be. That faith is required to be maintained by all of us, and we need to do whatever is available to us within the framework of law, as also in our ingenuity, again within the framework of law, that the court's orders, the verdicts do not remain merely the declarations or merely the paper decrees or paper petitions. The ultimate fruit reaches where it should reach. Friends, examples of the courts innovating and ensuring the fruits ultimately reaching the deserving are unending. The courts do evolve their own methods. The need for all of us to remind ourselves is, are we really seriously concentrating on execution part, the implementation part, be it the contempt proceedings or be it the execution proceedings, that seriously? I remember distinctly, even on the administrative sides, we used to discuss sometimes in the High Court that our judicial officers were also not very keen to take up the execution matters because of that credit or quota or whatever you count, that was comparatively lesser for the dealing with the execution proceedings, though they were required to devote much more time while dealing with an objection pertaining to, well, any objection of 2197 would be asking for a judicial officer to deal with the matter particular as a suit as such. But we as judicial officers also required to ask. Of course, the administration is also required to take note of that. But we as judicial officers are also required to ask ourselves that merely because we do not get that kind of credit point for dealing with an execution, that does not absolve us, or that may not be a right approach of ours of keeping execution at a bay, or, well, giving them lesser importance. It's not a question of comparative importance. A regular civil suit also requires the same importance, but then an execution proceeding would require equal importance. And once we start concentrating on that, a contempt matter, if it is pending, an execution proceedings, if they are pending more than a very short span of time in our courts, the faith factor is bound to be somewhere disturbed. The judiciary does its best to maintain that faith. But then wherever are the areas which are lacking, wherever the areas where we can improve, it's, I believe, our solemn duty to look for those areas, to work on those areas, and to evolve more methods where the orders are in fact implemented. Once we just imagine an utopian judicial system where not a single execution petition is pending in the court. Probably that would be a wonderful scenario. You will find more satisfied persons around us. It may not happen as such or immediately, but yes, the efforts can always be made. We had been making all efforts. The requirements are that Dipali Biswas kind of things or those scenarios, they have been curbed, but still they are needed to be curbed more seriously. In that context, well, innovating now with the and means all around advancement of technology, digitization, the data world as it is becoming now, as Yuval Harari would say in his that second classic Homo Deus, that the threat of the data overtaking even the humans as such, and we may be reduced to nothing more than the slaves of data. But that may be the next millennium. We may not go until then. But at present, when the data, the digitization as such, the data regimes of different kinds are available with us. We have been evolving, like we have seen the pandemic again. COVID, the last 2 years, has shown us again, that it's shown everybody, we in judiciary evolving, the methods, the judiciary is swiftly responding to the requirements of attending on the casework, attending on the needs of call of justice, virtual courts, and suddenly the virtual courts became an order of the day. We all are doing it. We have improved on that. Virtual court was just one evolution out of the necessity, we would say, that once we have those technologies now with us, as far as implementation of court's order is concerned, well, all other statistics, preparation of everything, swift, distribution of all the information, all done. But then, if we can employ those methods also for expediting the execution processes, implementation processes, they are going to go again a long way in ensuring that, well, that particular dissatisfaction anywhere, that even after having an order, the fruits are not available. If we are able to take that away, where the confidence building would be tremendous, and that confidence building is our biggest strength, the biggest strength of the entire judicial system, and that will go a long way in we evolving yet further on the judiciary, working always for everybody's good. Just a food for thought for all of you, particularly when you are having so much of technology and so much of the data regimes at your disposal. You know, friends, these days, this is when we intend to look at beyond horizons. We are aware of the propagation of a concept of blockchains, cryptocurrency, and the smart contracts. The smart contract, well, evolving out of the blockchain methodology, is that system of contract where the things are automated, the particular given fields are complete, the contract is executed, by itself, are those that coin vending machines are the classic example of that. Well, when you put a particular coin which you are supposed to put there, the entire circuit is complete. You get the delivery. Well, that is if you evolve on that, on smart contracts. I'm not saying immediately that, well, you put your decree also into a methodology of smart contract and you will immediately have the fruits going. But yes, these are the areas when blockchain technology could be used for several now international business relations, evolving of cryptocurrency and various other methods. If a methodology of that nature, akin to that, is thought of, is examined, where execution of an order could also come up when certain parameters are given. Friends, it may require, it may sound purely theoretical today, but yes, on these theories we have evolved some of the principles, and we have evolved the new ideas, new methods also. The Code of Civil Procedure, when it provides for something like supplemental proceedings, the concept had always been to ensure that whether these are injunctions or arrest before judgment or appointment of receiver, the concept had always been to ensure that the decree which is finally to be made is not frustrated. That is why these were taken as supplemental proceedings. If something like a smart contract, where on a given completion of given fields, a contract could be executed or a decree could be executed, I mean, when a decree, of course, has attained finality, and maybe the provisions for its reversals, something like Section 144 for restitution, etc., will also have to be provided. But a thought can definitely be given to this or other methods, particularly when technology now with us, rather than we allowing technology or dataism to rule us, and as Yuval Harari would say that there may be, after a few millenniums, data may be ruling you, but rather than that, we can always use that technology, use those algorithms, use those blocks by which the blockchain is created, or any other method to ensure that the process of implementation is swift, the process of implementation is not blockaded. Process of implementation of court's order doesn't, well, remain at the backbench. For that purpose, friends, what I have felt, and that is why I thought of saying a few of random thoughts on these aspects, that apart from shaping on, apart from sharpening our proficiencies as regards the rules of substantive law, even the rules of procedure, this, the fifth element of law of procedure, even if, well, in chronology it comes fifth, but it is by no means least. In fact, unless it is also attended at with the same zeal, enthusiasm, and vitality, all other processes, all of the learning, the other learnings on whether substantive law or other four elements of laws of procedure may not be leading to the ultimate confidence and ultimate fruits ultimate fruits to the deserving, and thereby it may not build confidence. So building of confidence is, since it's needed, it is also a part of all of us. We have to ensure that these discussions do not remain just the matters of discourse, but in fact, the fruits of the decree, fruits of the order go to the deserving as a matter of course. That is what is needed. That is what I hope, I trust, ILI here in this platform would look forward to, means develop on this theme yet further, how we can ensure implementation, and not simply by our discussions, but on the ground reality, how much execution we are able to deal with swift, fast, and complete the process so as to ensure that our system will keeps on moving further ahead, because the requirements would be always developing. There would be so many features, so many aspects of always developing. Maybe even in the implementation part also. I understand the learned additional advocate generals representing the government are also advocate. They are also here. See, the contribution of the government. One of the litigants who would be at, or particularly their officers would be at the receiving end of the contempt matters much more. See, contempt matters again. The approach of a litigant like the government towards the contempt matter is also going to be one of the areas to be attended at. But then, if the government is not able to evolve the methodology, because I understand, if I remember correctly, there had been so many of those litigation policies were being formulated, or probably that has become more kind of a rhetoric now. Every year you have a new litigation policy. I don't know whether you are evolving it every day new, or the old one, a new print, reprint only is coming up. But the litigation policies, if we look at them, the idea and the concept had been that unnecessary litigation, the government would be at the forefront of curbing it, and no unnecessary appeals, and at the same time, no unnecessary non-compliance. But if non-compliance still remain, the compliance has to be ensured. It is, in that sense, it is disheartening for a litigant to litigate over again for the purpose of, well, getting the fruits of a litigation which he has already won, whether it is a private opponent or it is the government. That second round of this litigation is to be curbed, and curbing by way of different methods to be evolved by all of us. That is the need of the hours, my friends. These automatic systems, these automations, I won't say that there could be a substitute of a judicial officer in the execution of decree, but something like smart contract, if that idea is thought of about the smart writs and the smart decrees, maybe we may look forward ahead, because the concept and the idea is that ultimately the rule of law prevails, and as was indicated by the learned speakers, the idea of, well, all the sense of justice, liberty, the main ideals, the goals around which we all are existing and evolving, well, they become the realities. For that, every effort from every angle is needed. Implementation, looking beyond the horizons, broadening the horizons is required. The methods which have been hitherto adopted by the courts have paved the way but proceeding on such innovation, such ingenuities, we need to, well, evolve more methods, more means ways and means that the orders remain. Well, ultimately, the orders do reach who deserve them. As there are, whenever, friends, we are to talk about execution, it appears as if we are discussing something negative, something troublesome, something where a level of helplessness may come up, or maybe providing a blockade to us. It's time for all of us to understand that, well, there is neither any helplessness nor the execution could be approached with negativity. We need to, first of all, as law professionals, whether as judges or whether as lawyers, we need to tell ourselves that execution is also our solemn duty. Execution, implementation is as much of our duty as is the duty to, well, towards disposal. That is, disposal is counted in numbers, but the execution, even if not counted in numbers, it's counted in the faith factor, in the confidence factor, and that is much beyond simple numbers. So, friends, there are several other methods, means, which we can always go on discussing. I would wish that implementation of court's orders, whether execution or continuing mandamus or contempt, etc., we keep on discussing about it, and we keep on evolving. Friends, we have come way ahead of those refrains of the courts, as we find in something like section 14 of the Specific Relief Act, that the court would not be enforcing a particular contract if its enforcement requires continuous supervision. It's not the concept of the courts, the dynamic courts, the 24/7 courts, the ever working courts now, that, well, anything which requires supervision is a big no for the court. But yes, supervision methodologies need to be developed, have been developed by the courts, but we have seen the results coming up, the concrete results coming up by way of the continuous supervision wherever it is possible and wherever it is needed. So, more than disposal, we need ultimately at the resolution of the dispute. That is what we all are meant for. So, I hope and trust we would discuss more about it. Thank you so very much for today. Thank you.
Thank you so much, sir. To conclude today's ceremony, I request Honorable Mr. Vijay Vishnu to take over the points.
Honorable Justice Shri Dinesh Maheshwari Sahib, Judge, Supreme Court of India, Honorable Chief Justice Shri Akil Qureshi, President ILI Rajasthan Chapter, Honorable Justice Dr. Vineet Kothari, former Acting Chief Justice Gujarat High Court, Honorable Justice Shri Sandeep Mehta, Executive Chairman ILI Rajasthan Chapter, my esteemed brother, sister judges, advocates, member of registry, ladies and gentlemen, greeting to all. On behalf of the Indian Law Institute Rajasthan Chapter, it's my privilege to extend a heartfelt vote of thanks on this occasion. I feel immensely grateful towards all the dignitaries who could spare some time out of their busy schedule to grace us with their presence and share some highly valuable thoughts. I thank you for such insightful words and thoughts worthy to be imbibed into life. Firstly, I would like to thank Honorable Justice Shri Dinesh Maheshwari Sahib for his encouraging words that would embolden the Institute to work towards the objective it has behind its genesis. Listening to such words would help the Institute gain momentum and work its way to the glory that it is meant for. The address elucidated some unseen aspect of execution by courts which need a slightly higher meticulousness, and we are fortunate enough to have heard about it in the address. I express my heartfelt gratitude towards the Chief Justice of Rajasthan, Honorable Justice Akil Qureshi, for gracing the event with his presence and gathering, and the Institute feels highly grateful to have listened to such intellect filled words and experiences and would be immensely benefited for the kind address coming from such a conscientious chief of the Institute. Further, I would like to thank Honorable Justice Shri Vinit Kothari for his kind address and wonderful interaction. The years of understanding and extensive knowledge about the field could be heard in the kind address. The wise words would help the Institute propel and sail towards its mission. Further, I would like to thank Brother Justice Shri Sandeep Mehta, Executive Chairman, ILI Rajasthan Chapter, for organizing the event and would congratulate him for its success. Such an event has made a motivational foundation for the Institute in its resurgence and revival. Lastly, I would thank all the advocates and the people in the gathering for assembling and witnessing such an insightful event. I would end by wishing you a good health and well-being. Jai Hind.
We are now seeing request everyone to stand up and honor the national anthem. I'm going to say we don't belong to the house. Thank you. Thank you.